Hello, everybody. I'm Phil Brandt, President and CEO of AIM Employers Association, and welcome to This Week at Work.
This Week at Work is the only show about the workplace that offers you front row seats and a microphone, featuring experts in human resources and employment law to bring you practical, timely, and accurate insights so you can more effectively lead your organization. It's Thursday, April 25th, episode 276. Today, a groundbreaking shift in workplace safety is making noise across a wide range of industries. With the introduction of OSHA's new Walkaround rule, third-party employee representatives are eligible to make the guest list. Are you prepared to support additional RSVPs from these plus ones? Join us alongside special guest Tom Chibnall as we chart the path leading up to this change and explore what lies ahead for employers, workers, and regulatory bodies in this evolution of workplace safety. Plus, we'll touch on FTC non-compete news and new developments with DOL overtime exemptions. All this and more on This Week at Work.
Hello, everyone. Welcome back to This Week at Work. Happy to have you with us this Thursday. We have our favorite fan from Ogletree and the worldwide famous Tom Chibnall. We like to call him Chibs. Chibs, welcome back to the program.
Hey, thanks, Bill. I appreciate you guys having me, and excited to be here with you on a week full of crazy news.
Well, you know, we wanted to take advantage of having you on the program when there were some exciting things to talk about. You know, Bert normally sips in and he's doing all this, but we want to give him the break today. And Tom, I'm glad you're able to be here to talk about it because Bert's been setting the stage until today on some of the things we're going to talk about, but you can bring it home for us. But speaking of bringing it home, last week had Coach Craig Berube on the program, the Stanley Cup winning coach for the St. Louis Blues. Excuse me, and I'll make sure to introduce him appropriately. Tom, I hear you play a little bit of hockey.
I do, not well, but I play it and I love it. So yeah, I was excited to hear that Coach Berube was on there, and I wish I could have been there and seen it, Phil. But unfortunately, OSHA had other plans for me, had me on site with a different client that day. So I blame them for making me miss Coach Berube.
Yeah, now you're not, when we're talking about playing hockey, I'm referring to playing like ice hockey with a stick and a puck, not like NHL on, PlayStation or something like that.
No, this is my form of exercise, Phil. This is how I keep the pounds off. Is I play ice hockey at night with a bunch of, let's say, people of a similar age as me.
All right, that's good. Have you skated with any of the Blues or ex-Blues or any other NHL players?
No, I have not. Let's just say that skill level is a little bit beyond mine at this point.
All right. That's fair enough. Well, we're going to get on with the program. We got a lot of good things to chat about today. Let's see what we have for our poll question set up. A few questions centered around today's topic. First off is, how harmful would it be to your business if you could not enforce the non-compete agreements that you have in place today? It's a 5-point scale. Give us an idea of what that is, because we're going to talk about that, and it sounds like they're not going to be very enforceable. The second question today is, what word comes to mind when envisioning a third party being present during a government inspection? Another great question, Nick, because guess what? They get to bring along. And Nick, I like how you introduced that. Made it sound like we're going to have a party at the workplace between the guest list during your introduction and so forth. But I just have a vision, of people bringing in all kinds of crazy third parties that will maybe not serve the best interest of the company or the employee, maybe in some cases. Then the third question is, have you recently audited the exempt and non-exempt status of your employees? Because that rule is changing also. So we got a lot to talk about. Nip or Chibs, are you ready to kick this off with the fastest 6 or 12 minutes for employment law?
I am. Let's do it.
All right, Nick, pull that lever, buddy.
All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
Well, Phil, you teed that up great for us. We've got two recent developments, big developments, particularly in the agency side of the government. The first one is the one that you've mentioned right from the get-go, and that's the non-compete issue. This week, the Federal Trade Commission finally announced its final rule, not just a proposed rule, but final rule, having voted on it 3-2 by the commissioners, to essentially ban non-competes. And yes, you heard that correctly. That's what they're doing. So they are taking the steps now to put that rule into effect. It will go. The rule is essentially saying that your non-compete agreements are going to be invalid. And this isn't just moving forward, but it will also be retroactive under this new rule. So meaning any agreement that you have currently that has a non-competition portion of it, that's going to be invalid. Now, it's a good time to kind of mention what's the difference between a non-compete and a non-solicit.
I think that's a good idea. Yeah.
Because these
two
go
different
hand in hand.
agreements. Yeah.
Two different agreements. So let's start with the sort of more limited one. Non-solicit is that you cannot go and, recruit clients. If you're a salesperson, you can't go take your book of clients that you developed with your current employer and go to another employer or even start your own company and solicit or contact those clients for their business. Whereas a non-compete says you can't even work in that area doing that very particular job for any other employer. So for instance,
compete against, I kind of always tried to think of it as, I can't compete against my current employer in their marketplace. And the challenge to that is when you work for a national employer, right? Or you work for a local employer, but you want to stay local and all you've done is worked in that industry.
That's right. Yeah. And that's the kind of catch of the non-compete, right? That's why it's so powerful. Say you're in a business where you're selling cranes or something, and you're one of two people in town. If you want to leave that place to go to the other person, you can't under that non-compete. You're looking to move. You're having to leave the region. And if you're national, like you said, Phil, that's really handcuffing. So this issue.
I even think about like a simple car dealer, right? A car sales might have a non-compete today that prevents them from, going to the car lot across the road. They're often clustered together in a community. And now this would give them the flexibility to do that.
Yeah, and that's right. And so this is kind of a little bit of a recent trend across the state. So typically states have been allowed to enforce their non-competes, whether they want to or not, kind of make their own rules. So for instance, us here in Missouri, non-competes are totally okay. And in fact, people use them all the time. Whereas if you go across the river to Illinois, they're much more limited. You can't have non-competes for certain people who are making a certain amount of money. It's targeted toward eliminating non-competes for lower income workers. Now, if you go other places like California or Minnesota or Oklahoma, or even sort of moving into Washington, these are just sort of blanket bans on non-competes. And we're seeing the federal government sort of step into those roles, which is why I think you're going to find there's going to be a legal issue here that's going to have to be resolved by the courts. And that's going to be a constitutional issue. One, does the FTC have the authority to do this? And two, if it's already been been delegated to the states, are they infringing on those state rights? So, what I could tell your listeners here is that this is going to take 120 days for this to go into effect. No need to rush into revising anything at the moment. But, keep it in the back of your mind that you might have to sort of revise your agreements with your employers or your employees, and you might even have to scrap some of the ones that you already have. So keep your fingers on the pulse of this one. We do expect there to be a significant legal challenge because, as you'd imagine, employers have a very, very high interest in this. I mean, we're not protecting just the assets of the company, but also things like trade secrets get involved here, disclosures, what people can share. The idea the Federal Trade Commission is doing here is trying to open up competition by doing this. But in fact, it's very much restricting what companies can do. So that's something to keep an eye on.
So Tom, understanding Ogletree's firm position is know what you have in place, right? Let's be aware of what we have in place. Let's know who has the non-competes. Let's make sure we're separating out non-competes from non-solicit to some of these other things that exist. That sometimes get bundled into one statement, non-compete, non-solicit, it's one agreement. So let's know what we have in place. And then let's see what the law challenge is before we go out and make any changes and what happens with that to see if there's a delay in the implementation because something's going to change. Is that maybe the school of thought?
That's right. And sort of practically speaking, Phil, I mean, if you've got a contract that's provision of it or even the whole agreement is void, it's like you're working without the contract anyway. So there's no real reason to rush into recreating something if you're just
Right.
if essentially got a useless piece of paper.
Right. Would the non-compete, if they are combined in one, which I do see a lot of employers submit them as one, and they don't always separate them into two agreements. If my non-compete is void, but I still have my non-solicit language within that, I think that's where it gets a little bit tricky to make sure it's not so mundane. The language isn't so gray that one voids the other.
That's
That
right.
would be something we want to look for.
Yeah, that's right. And to look for something called a severability provision in those contracts. And what a severability provision does, it says if one portion of this contract is void or declared void, it doesn't invalidate the other portions that are not.
Yeah, very good. Yep.
Yeah, so you might see that, and it's oftentimes put in there. It's usually, I'll tell you, it's usually towards the end of the agreement. So you might want to look there if you're looking for it, but check for those. But really, the FTC is taking a real broad approach here, painting with a broad brushstroke. So,
Great.
I wouldn't be surprised if those non-solicits come under fire too.
All right, great. What else you got for us, Chibs?
So the other big one is the the sort of OT or overtime regulations and rules changed recently, and that change is going to go into effect pretty soon for many people. So it's going to be a two-tiered change, but really what we're doing is we're changing the sort of classification standard for exempt and non-exempt workers. So as you might know, your exempt workers may not be subject to overtime, but that's based on how much they earn. So that is getting raised. So for instance, it's going to be two-tiered. One part is going to go into effect in July of this year, and then the second sort of wave is going to go into effect January of next year. And what we're doing is we're increasing sort of the minimum qualifying salary for what we've considered traditionally, white collar or not our, exempt workers, and that's going up basically from about $700 a week to now about $1,200 a week, or almost about $1,200 a week. So it's almost going up about 50%. So it's a lot, and the big sort of takeaway here is that the threshold, when you're talking about an annualized salary, used to be essentially about a little under $60,000 for your exempt folks who are basically for that non-exempt, not exempt classification. Now it's gone up a little bit. I'm sorry, it's gone up to 60. It used to be about 40 or about 35. So it's gone up, and now it's going to go up even more. And it's going to go up in July. The weekly threshold is going to be about $844 a week, or about, if you're annualizing that, about $43,000 a year. And then in January of next year, it's going to go up to essentially $58,000, almost $60,000 per year annualized salary. And what this means, and this is the big issue, is that it's going to require many employers to go back and audit who they're classifying as exempt and non-exempt. Because as we know, if somebody's non-exempt and they should be getting overtime and they're not, that's a problem.
Yeah, we've seen the case law on that give out high dollar rewards.
Yeah, exactly. And I will say that, this is sort of a retread. Many years ago, under the Obama administration, there was an attempt to do this very kind of similar concept, and the court struck it down. So there's a likelihood that happens again, but we'll have to see how that legal process plays out. But this isn't a new thing by any means. It's just sort of round two. It's been a while. It's been a while since we've seen it happen. So, but like you guys, it's as the whims of Washington swing, so do the agencies.
Yeah, no, that's true. And I mean, we get stuck in the middle on that. I have a sense that while this one might get some challenge, I think the day's coming that we're going to see the change here. That I feel like these are going to be a little bit more sticky than it was the first time around, just due to the way the agencies and things are moving right now, where I can see the non-competes getting delayed.
Yeah. I agree with you, Phil. And you don't have to look too far to sort of see practical examples. It's just a lot more expensive to live these days, and you see prices going up. And I think the government is sort of taking that into consideration and trying to say we need to get wages up to speed to compensate for inflation and for other various sort of cost of living, which is why I agree with you. I think this one's got a lot more ability to stick than perhaps the FTC one.
And I know our members and the employers that, you know, I deal with all the time, we said, we need to slow this wage inflation down. I mean, it's one of the top concerns of executives is wage inflation and being able to continuously, you know, pay an increased wage and manage, you know, the overall inflational factors of their business. So, we're stuck in this whirlwind of change that's really expensive change for us on all fronts.
That's right.
All right.
Yeah.
Tom, that's great. Great insight. Anything else from Lawyer on the Clock?
No, I don't know if I have enough time.
All right. Well, we got some other things to talk about. And I want to get into Philbert's Forum. So we want to take advantage of your expertise as the worldwide Ogletree expert for OSHA. And Nick has put together some great slides, and we're going to do a little bit of test your knowledge. We're going to stump the lawyer here if we can. Nick, can we kick off Philbert's Forum?
You've just entered Philbert's Forum, where we peel the onion back and take a lighter look at the workplace.
All right. Okay, Tom. So what we want to do here is we got a few photographs we want to show you now. In each of these photographs, you're going to have to look really carefully, very closely. There is a hidden safety hazard in each of these photographs, and we got to be careful and make sure. See, we're going to test your knowledge to see if you can identify it as if you were on the Walkaround. All right. So think about this. You're on the Walkaround, and let's see if you could identify the safety hazard. Nick, let's see the first one.
It's up right there.
All
right. I don't know if I can describe it for our audio listeners just because, well, that kind of could give it away. But there is a safety first sign that is being hung. So what do you think, Tom?
Well, kudos to these folks for thinking safety first. It's a shame they're not performing safety first. But, you know, you see here in this picture, we've got a gentleman who's basically standing on the railings of a staircase. And while that looks like he might have the required 3 points of contact, let's just say those aren't the right 3 points of contact.
There you
go.
All right.
Sits behind him, right?
Ding, ding, ding. You got that one right, Tom. Good job. You're 1 for 1. What else you got, Nick?
Well, we have we have some, I don't know, some grinding possibly going on, but you know, with grinding comes, well, you're moving metal around, you're moving things around, so stuff has to go somewhere. What do you see here, Tom?
Well, well, Nick, this is a OSHA officer's field day for sure. But one of the first things you see is that you got no guard on this grinder. It's spitting out. It's certainly spitting out sparks while someone's trying to catch it in a paper bag. So we got some flammability issues. But you know, even if we're willing to excuse those, our guy who's catching the sparks in the plastic bag should probably be wearing some eye protection, I would think. But you know, he's not taking the effort to put those on.
No, he's not doing that. He's catching sparks. There's no, there's no guard. You got it all right, Tom. You're off for 2 for 2. All right. Now we can see why Ogletree is such a fan of you, Tom. What else we got, Nick? Any more?
Yeah, we have 2 more, so we can go through these quick. But, I mean, this is a bridge scene. Apparently, we're working on the bridge, but we should probably be working on the employees as well.
Yeah. Look at this one. I could tell the folks in the audience that the bucket of an excavator is not a proper device to be sitting in or working from. It's meant to move earth, not people. And then on top of that, we've got a gentleman who's working on a ladder. He's got 3 points of contact, but the ladder is in a river. Probably not the most stable, secure anchorage point for him, amongst many other things here.
Yeah, and there's a hidden hazard up. If you look along the pillar on the right-hand side, looks like there's a guy on break, like you will often see on a roadside crew. You know, there's 2 guys working and 8 guys on break. But this guy's on break, his feet hanging over the edge. You know, looks like he's ready to maybe jump or fall off into the river himself.
Yeah, we might have some fall protection issues there as well, right? No, nothing right. Securing them to the bridge.
All right. Any others, Nick?
Yeah. And by the way, who needs a water cooler when you have a river? So
that's right.
All right, we have this final one here. You know, I'm not sure that what is happening is what was intended, but this would even be an OSHA problem, probably even in war. So you tell us what we're seeing.
In wartime.
Yeah, right. Other than the fact that we have a powered industrial truck, a forklift that's certainly gone off the edge of a loading dock. It seems to be carrying a warhead of some sort. Which probably under OSHA's process safety management standards, probably a big no-no.
Yep.
But let's just say whoever is responsible for this probably needs to be put back in the forklift classroom and taught how to drive.
Yeah, that you can't tell, but that picture came from China, Tom. That's the Chinese military facility there. That's not the United States government warhead. All right.
Yeah, right.
Okay. There you go. You got them all right, Tom. I know those were hard to see, but your trained eye expertise, you found them. Well done. Good job.
Right.
Okay, let's move on to the really meat of the program here. And Tom, we want to really take advantage and spending, the next 10 minutes talking about this new final rule with OSHA as it relates to the walkaround. This can create some problems for employers. There's some things we have to be aware of. I'm sure there's going to be some case law that will define our way forward as well. I think, but let's just start with what's the new rule? Bert has told us it was coming. And what's the advice we have to get ourselves oriented with it and maybe get the right controls in place to be prepared should we ever have a problem?
Yeah, so let's start off with what the rule is and what it used to be. So what it currently is that, in a walk around or an OSHA inspection, when OSHA shows up to your site, your employees can have the ability to designate an authorized employee representative to accompany OSHA. Currently, right, that person needs to be an employee. Or it needs to be a member of the bargaining unit if you have a unionized workforce. Under the new rule, the floodgates sort of open. The guest list, as Nick called it, gets much more expansive. And now it just needs to be any authorized employee representative who has basically relevant knowledge or skill in safety and health. And here's where it gets problematic, or has a skill in communication. That's it. That's in the new rule. And I'll tell you, as a lawyer, we love to parse words. We love to really narrow in on what they mean. And the word communication can mean just about anything, as you well know.
Oh, for sure. Yeah.
So what this does, this new rule, which is set to go into effect May 31st, so the end of next month, what this new rule does is it allows employees who may not have what we typically call an authorized representative at the workplace. It allows them to sort of bring in whomever they want. They
be careful when you say +1. Bring your own +1, right?
Correct. That is correct. So my mind already starts racing as soon as this rule is starting to be drafted. What about a personal injury attorney? Let's say there was OSHA's there because somebody got hurt. Now we've got a personal injury attorney on site taking pictures, talking to people, or
passing
maybe
out cards.
Right, passing out cards. Or what I think the rule is designed for, might still have an effect, and that is the promotion of union efforts, promotion of organized labor. We all know that this administration has been very supportive of organized labor, has been really sort of pushing them to the forefront. And what we see is that the agencies, OSHA is taking a step out of that playbook as well, and is saying, well, let's get more of these organizers involved, because typically, if they're not actually the representative, the bargain for unit, they're not allowed. But now they could be. So you can imagine a local union sending out their PR person to go through the walk around because they've got a communication skill, and they might be live tweeting or live streaming these things as they happen. Right. These are concerns that many of us on the management side have. Not to mention the fact that the way the statute is written, the OSHA Act, that authorized representative is not defined this way. It's much more limited. So that's the new rule, and that's going to go into effect at the end of next month. And what I can say is, and this is what I've been telling clients all along, is that you do have a lever to pull in this game. You do have a play to make, and that is your constitutional Fourth Amendment right. The Fourth Amendment says you're free from unreasonable searches and seizures, and that applies to businesses as well. So as a business, you want to think of yourself as an individual. So if OSHA comes to your house, or let's say, put a different example. Let's say the police come to your house and say, we want to come in. Your first instinct should probably be, do you have a warrant?
Right.
I'm telling clients, you might want to rethink that now and have that same approach with OSHA. That's your right. You can refuse entry and require the government to seek a warrant, and to get a warrant to allow them to come in. And part of this is, that is a lever to pull. It's sometimes a challenge to do that because it takes a little gumption to do so. And many people see a government agency come up to your doorstep, flash their badge and say, hey, I'm from OSHA, I want to come in. And our instinct a lot of times is to say, sure, come in, sit down. How can I be hospitable? Because we don't want to make them mad. We don't want to make this worse than it already is. But we might want to start rethinking that approach depending on who's with them.
So it's been a while since I've been a leader of safety, but I did used to do that for a pretty, maybe 10 years of my career. I was focused specifically on safety management and leadership, and we would always have, reviews once a year of our policy. If OSHA shows up at the door, what are we going to do? This is with the management personnel leadership. So we were prepared, right? And we had a decision tree of when we would say, yes, let's go see what you came here to see, or no, we want to, require you to get a warrant to come in. We want to call our legal support and so forth. And I think that's probably the first step for employers is to know when they want to say yes or no, and how do they make that decision? What are the factors that would allow you to make that decision? I think I'm going to be more likely to say no when there's an additional third party there who I may understand or not understand the intention of that third party. That's going to be the trick. If it's, I'm in the middle of a union campaign, and almost every union campaign I know has had complaints that went to OSHA, and OSHA shows up the door, and that's part of what you're managing. And now it's, the union boss who wants to come in, right? That's going to be a certain position. It's a stranger. It's a plaintiff's lawyer. It's a family member who's involved with safety. It's the news media who has an expertise in communication, would love to be a part of this. That's when you're going to want to understand when to say no.
That's right. And Phil, one thing that you said there is, I can't emphasize it enough, is to have a plan in place. Yeah. Know what you're going to do before they even get there. And like you said, some of this is on the fly. You have to read the situation, who's there, who's not there. And it governs how you're going to act that, but know what to do, because it's going to happen quickly. And a lot of times, you're putting people in an uncomfortable situation that they're just not typically handling. But if you know what to do and know who to call and know who to get involved, that really eases the stress of those environments. So yeah, I would start revisiting those OSHA visit plans that people have in place. If you don't have one, think about getting one in place, and put this added factor in. What happens if somebody from outside the agency or outside our organization shows up?
Yeah, and I know this is something that your firm does. This is something that AIM does. It can reach out to you, Tom, if they wanted to, or AIM. What's your email, Tom, if someone wanted to reach out to you and get some assistance?
Yeah, sure. My email is my name, thomas.chibnall@ogletree.com. And yeah, this is something we do. Just this week I go on site when OSHA shows up. I'd show up, help the client out, walk through the process with them. And it's okay. And I will tell everybody, it's okay to have a lawyer there. It's okay to protect your rights. And OSHA doesn't think twice about it. I mean, they understand it. It's certainly not it's not confrontational. It's mostly they understand why you're there, and they don't think less of you for having your lawyer there, or even some other representative that you want. So yeah,
I think that just says to me, it's a signal that you know what you're doing and you know why you want to do it. I got a couple questions I want to get to the word cloud as well, Tom. If you can give me just a minute. First of all, are anywhere in the regulations, do employees have the right to bring more than one representative, or is it a single representative?
So it's the way it's written, it's just singular, but the way the regulation's written, the rule, it gives all sorts of discretion to the compliance safety health officer, the actual OSHA inspector there. So the OSHA inspector might say, well, we've got a unionized workforce, so we need the union here. they're already authorized. But you know what? They want to bring they want to have a PR person, or they want to bring an outside safety person in. Those people are now going to be part of that. And if anybody who's spent time in a kitchen will know, the more cooks you have in the kitchen, the harder it is to get things done.
Yeah.
And sometimes the worse the dinner is that you serve. And that's the kind of strategy and the mindset I have, is that the more people involved in this, the messier it gets. And I can tell you from experience, when I've had more people involved in those walk around activities, the inclination for the compliance officer to go outside of the scope of whatever he's there for is much, much greater. In large part because you have multiple people looking at different things. And while you might be there to talk about, forklift training, you might have somebody whispering in their ear, "Oh, they've got exposed electrical panels here. Let's go look at those." And now now the compliance officer wants to go look at that. So more people involved, the harder this gets. But the regulation is written, it's designed for one authorized representative, but the discretion it gives to the compliance officer really sort of swallows that.
Yeah, and that's the scary part, right? Compliance officers are going to not want to be called in and embarrassed because they made the wrong decision. The fail-safe decision for them is to say, "Sure, bring them in."
Yeah.
That's their fail-safe.
Yeah, and going back to
I would assume that's what you're going to get.
Yep, that's right. And going back to a previous comment you made about unionized workforce, if somebody from the union comes in or even wants to come in, and they get denied, well, they have recourse to take action about that. They've got public communications, public relations folks who could say, "Hey, we were denied access. Look at this employer not doing this." And it doesn't have to be a union; it could be anybody doing that. So that's just an example of kind of the pitfalls of this rule.
I haven't met a union boss yet that's not an expert in safety. All right. So, hey, let's get to the word cloud real quick before we go here. What do we got here, Nick? Can you tee us up?
Yeah, we have a lot of good, across the board, a lot of good letters here, or words. Letters make up words. So we have necessary. That's one that just came in. Agenda. These are words that come to mind when envisioning a third party being present at a government inspection. Neutral, nervous, disruptive, assistance, annoying, yikes, frivolous, and oversight. So those are words that come to mind. The frivolous
one is it? That's an interesting response. The frivolous response to me. I don't think this is going to be frivolous. This is going to be intentional, purposeful. Maybe I can agree with agenda for sure.
Yeah. I'll tell you, the words that jump off the page to me that I see all the time are disruptive and nervous. People get nervous, and it is disruptive. It is disruptive, and that's one thing not to forget about, because you have a right not to have your business be completely interrupted, like shut down production or whatever you're doing. So yeah, those are words I hear a lot: nervous and disruptive.
All right, there you've heard it from Chibs. That's his hockey name as we know him. So we're happy to have you on the program today, Tom. Thank you for stepping in, and we'll have Bert Garland back on next week with us. Until then, we will go. Until then, go out and be good to somebody. Take care.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment. LinkedIn, YouTube, Spotify, Apple Podcasts, we're everywhere you are. Don't forget you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.